So then what happened is on May 22nd, the court imposed the consultation protocol, a timetable, and the MOU on Platinex and KI. This is where the legal system becomes a funnel. KI was pushed into the court system at the beginning by Platinex. After a brief legal recognition of their perspective, the court imposed the agreement in favor of drilling. So the reduction of Aboriginal and treaty rights to the right to be consulted eventually led to the point where the judge jailed the KI leadership. Oh, okay, sorry. Oh, this is what I want. Okay. It is important to remember that throughout the legal events, there was also community and solidarity organizing to raise public awareness of KI's struggle and build alliances. Okay. This image is from a rally at Queen's Park on September 21st, 2007. This rally involved 3 different First Nations. KI was there, as well as the Ardoch Algonquin, who were also protesting mining exploration on their traditional territory, and Grassy Narrows, who had been having a blockade against clear-cut logging on their land since 2002. The rally was organized by the Rainforest Action Network and the Christian Peacemaker teams. Anishinaabe Nation, a treaty-based political organization that represents many communities in Treaty 9, was also there. Now, eventually, the Ardoch Algonquin and KI formed an alliance in the face of court orders ordering both communities to stop protesting, stop preventing mining on their traditional territories. Okay. So following the May 2007 decision, the conflict between KI and Platinex escalated. In September, Platinex and their consultants flew into the community. They were met at the airport by community members, and after a lengthy discussion, they decided to leave. In October 2007, Platinex sought a court order allowing it to begin drilling and ordering the KI community to do nothing to prevent Platinex from doing its exploration. KI appeared at the court and explained to the judge it could no longer afford Canada's justice system. It was nearly bankrupt. It released its lawyer and left the courtroom. The judge continued with the hearing without them being there and ordered archaeological pre-screening and drilling take place without interference from KI. KI continued to publicly insist that according to its own law and the treaty, it had a right to say no to the project. In December, Platinex brought the KI leadership to court again to argue that they were in contempt of the court order. On this basis, the judge found basically KI had been publicly stating it wouldn't allow Platinex on the land. On this basis, the judge found Chief Donnie Morris, 5 band councillors, and 1 staff member in contempt of court. KI did not contest this finding, although one of the band councillors did appeal the finding. Chief Donnie Morris explained that he did not mean to disrespect the court, but KI had to follow their own law as well as their own understanding of what their rights were under Treaty 9. He said, "I stand by the fact that the land I'm on now is our land. I believe God put us there. God gave us a language, the animals to live off, and we just don't want to see development on that area. As a treaty partner, I expect to be treated as a partner, not where one is superior to us." Okay. A sentencing hearing was held in January 2008, where Chief Morris explained that he had no choice in not allowing Platinex on the land, partly because he had a mandate from the community, partly because he had to follow his sacred duty to protect the land, and partly because there were still aspects of the treaty, how to share the land rather than to see it as a surrender, that still had to be worked out with Ontario before any kind of development could proceed. Ontario and Platinex also made submissions about the sentencing for contempt of court. Platinex asked for jail at one point and then backtracked. Ontario asked for a fine that hurt against the already impoverished community. On March 17th, 2008, Justice Smith sentenced Donnie Morris and the others to 6 months in jail. This is a very lengthy sentence for contempt of court, okay? Generally what happened, for example, in the protests in Clayoquot Sound in BC in the 1990s, early 1990s, late 80s, people would be sentenced to 30 days for contempt of court. Okay, so it was a lengthy sentence. The leaders of the Ardoch Algonquin First Nations had also been found in contempt of court for violating a similar order against their community in mid-February. Bob Lovelace was sentenced to 6 months in jail, and Paula Sherman had heavy fines ordered against her. Okay. So the judge in the KI case emphasized the rule of law, that when the court makes an order, right, public defiance of that court order cannot go unpunished. The rule of law meant that the court had to uphold Canadian law. The judge explained that if there were two laws, one for Aboriginal people and one for non-Aboriginals, the administration of justice would fall into disrepute and there would be chaos. So the KI6 had to be punished by incarceration. The judge in the Ardoch Algonquin case had made similar comments about the rule of law when sentencing the Ardoch Algonquin leaders. So this is where the assumption, right, that traditional KI law and Canadian law are always going to be in conflict gets entrenched. Platinex's lawyer during cross-exam asked Chief Morris several times what he would do when Canadian law and KI law conflicted, which law would be primary. So that reflects a concept of the rule of law as inherently unitary. That means that the rule of law could not work without strict obedience and a very strict hierarchy of rules. There's no room for any kind of legal pluralism in this. It's a colonialist concept that's belied in Canada's acceptance of Aboriginal rights as sui generis. That's supposed to be a unique kind of law, something different. And it also is contrary to the enshrinement of Section 35. What it does, what that response does, is it protects the court's jurisdiction, and thus it protects Canadian sovereignty from Aboriginal people's claims to sovereignty and self-determination. Here I'm following Patricia Monture Angus's argument that the courts cannot deliver justice for Aboriginal peoples because to do so would require them to question Canada's and thus their own jurisdiction. Okay? The fear of questioning their own jurisdiction is a powerful deterrent to understanding and applying First Nations law as an equal contributor to the development of Aboriginal rights doctrine in the country. Okay. It was a very interesting day in court that day. When the judge read out the sentence to jail, there was silence and disbelief in the courtroom. People were visibly upset. And for those of you that have done any criminology courses or understand anything about the Canadian justice system, there already is two justice systems for Aboriginal people and non-Aboriginal people in Canada. Aboriginal people are vastly overrepresented in jail, as you know. Okay, so this is Chief Donnie Morris is in the center, and the others are band counselors. They were jailed in the provincial jail in Thunder Bay for, I think they spent 63 days in jail altogether. Again, there was community activism around the jailings. Okay, there were vigils at the jails in Thunder Bay. One of the counselors imprisoned was a woman, so she was kept in the in the district jail in Thunder Bay. There were teach-ins at Lakehead University. There was a lot of activism in support of Bob Lovelace at Queen's University, where he taught, and different alliances were made with the student union at Ryerson and labor unions, including QP and the CAW. Letters of support came from Amnesty International and the Anglican Church of Canada against the jailings. So as the two First Nations were struggling in similar situations, support for both began to coalesce. And this poster is for a rally in support of the KI6 and Bob Lovelace after about 2 months after KI was jailed. Now, it was planned, and by coincidence, it took place just a few days before the Ontario Court of Appeal hearing into the appeal of sentence. Okay. Now, it's important to remember that at the Court of Appeal, only the sentence was appealed, right? Not the finding of contempt. One of the band members, John Cutfeet, did appeal the finding of contempt, and it was set aside eventually. The other thing that happened is the Court of Appeal heard the Ardoch Algonquin and the KI case together, and the Court of Appeal released the jailed leadership, stating that the sentences were too harsh. Okay? It explained that the concept of the rule of law was much more than simply following court orders. The court commented that the enforcement of the injunctions by imprisonment could not help but emphasize the estrangement of this community and Aboriginal peoples generally from the justice system. the use of incarceration as the first response to breach of the injunction dramatically marginalizes the significance of Aboriginal law and Aboriginal rights. Okay? So this opens up again, right? It's a little bit more of an open decision to KI's traditional law and the Ardoch Algonquin traditional law than the sentencing decision was. It recognized that the First Nations protesting mining activity were doing so through a respectable interpretation of Section 35 rights. Okay? So this means that Ontario mining exploration companies can no longer get around the duty to consult and accommodate. Okay? It said very clearly that Aboriginal law and Aboriginal rights are just as important, more important.